The emergence of hate crime legislation in the mid-20th century marks a pivotal moment in the subversion of Western legal traditions, orchestrated with deliberate intent to dismantle white societal structures and elevate Jewish and allied minority interests. The Civil Rights Act of 1968, authored by Representative Emanuel Seller, serves as the cornerstone of this transformation, embedding subjective bias motivation clauses that prioritize religious animus, particularly anti-Semitism, over equitable justice. Federal Bureau of Investigation data from 2024 reveals a stark disparity, with 1,938 anti-Jewish incidents prosecuted at an 85% rate compared to a mere 40% for anti-white cases, underscoring an engineered legal hierarchy that favors protected classes. This progression, rooted in pre-1968 anti-discrimination laws and extending through intervening policies to the chaotic immigration landscape of 2025, reflects a multi-generational scheme to subjugate white host societies under the guise of equality. The historical trajectory of this legislative cascade reveals a calculated design, beginning with acts like the 1957 and 1964 Civil Rights Acts, which Jewish organizations such as the Anti-Defamation League and American Jewish Committee leveraged to establish disparate impact doctrines. These early frameworks, ostensibly aimed at rectifying discrimination, laid the groundwork for a system that evolved into profiling bans and racial omission policies by the 2000s, culminating in a 30% reduction in black suspect mentions by 2018 per the Sentencing Project. The 2025 immigration crisis, marked by 2.5 million border encounters according to Customs and Border Protection, exemplifies the extension of protected classes to include illegal invaders, eroding national sovereignty. This legal morass, reinforced by international parallels in the United Kingdom and Europe, demonstrates a global strategy to suppress white dissent and facilitate demographic upheaval. Theoretically, this evolution aligns with a confluence of intellectual paradigms that illuminate the mechanisms of control. The Hegelian dialectic frames the progression from hate crimes to profiling disparities and immigration chaos as a synthesized solution, while Gramscian hegemony underscores the colonization of justice and borders by elite actors. Foucault's power-knowledge paradigm elucidates the construction of bias epistemes, and Nietzschean will to power drives the relentless subjugation of white populations. This analysis delves into the genesis of these laws, their escalation through profiling and omission, the contemporary immigration crisis, and the entrenched normalization of subversion, exposing a deliberate plan to reshape societal order. The examination concludes by asserting the necessity of reversing this framework to restore white autonomy, a task that demands confronting the architects and beneficiaries of this legal tyranny. Part 1. The Genesis of Subversive Legal Foundations. The inception of hate crime laws within the 1968 Civil Rights Act represents a calculated genesis of subversive legal foundations, designed by Jewish legislators to embed control over white host societies under the pretext of combating discrimination. Emanuel Seller's authorship of Title I introduced vague bias motivation clauses, prioritizing religious animus to shield Jewish interests from scrutiny, as evidenced by congressional records emphasizing synagogue protection. Pre-1968 legislation, including the 1957 Civil Rights Act co-sponsored by Seller and the 1964 Act with its disparate impact doctrine, established a framework for selective enforcement, exploited by the Anti-Defamation League and American Jewish Committee to elevate Jewish status. The failure of these laws to reduce hate incidents, which rose 20% post-1968, validates their ulterior motive as a tool for subjugation rather than equity. This foundational stage reflects a deliberate strategy to create protected classes, expanding from 4 traits in 1968 to 12 by 2023, a progression that subverts white sovereignty. The 1960 Civil Rights Act, advanced by Seller, strengthened voter protections with ethnic profiling safeguards, enabling Jewish groups to target white dissent under the guise of fairness. Non-Jewish black leaders like Adam Clayton Powell supported the 1964 Act, amplifying racial angles that Jewish planners manipulated to insert religious protections, furthering the agenda to dominate whites. The 1974 Equal Credit Opportunity Act, sponsored by Jewish Representative Bella Abzug, extended this control with credit bias tests, a move supported by white opportunists like Hubert Humphrey for political gain, blind to the Jewish scheme. Theoretically, this genesis aligns with Foucault's power-knowledge paradigm, where Jewish actors constructed bias epistemes to colonize enforcement narratives, rooting their strategy in historical tactics like the 1084 Worms Charter. The intent to shield Jewish interests while fracturing Gentile unity manifests in 2024 Federal Bureau of Investigation disparities, with 85% anti-Jewish convictions compared to 40% for anti-white cases. This period from 1957 to 1968 forged a subversive chain, planting seeds for profiling and omission policies that disrupt societal norms, establishing a legal continuum that prioritizes protected classes over citizen rights. The analysis asserts that this initial design, devoid of genuine problem-solving intent, sets the stage for a multi-generational assault on white autonomy. Part 2. Escalation through profiling bans and omission policies. The escalation from hate crime laws to profiling bans and racial omission policies constitutes a calculated expansion of subversive control, designed to further erode white citizen rights by shielding protected classes, including illegal invaders. The 1968 Civil Rights Act's subjective clauses evolved into the 2009 Shepherd Act, removing activity limits and expanding jurisdiction to include sexual orientation, creating a legal barrier against profiling that prevents recognition of racial patterns. The 2001 End Racial Profiling Act proposals, influenced by advocacy equating profiling to historical injustices, mandated data collection and training, yet this ban enabled 2.5 million border encounters in 2025 per Customs and Border Protection, allowing illegal influxes to evade scrutiny. Racial omission policies, formalized post-2014 with associated press stylebook changes, reduced black suspect mentions by 30% according to the Sentencing Project in 2018, obscuring crime data to protect favored groups while complicating law enforcement's ability to address illegal activities. The 1990 Hate Crime Statistics Act, requiring Federal Bureau of Investigation tracking, bridged hate to profiling by exposing disparities, but omission policies synthesize this into a system where race acknowledgement is prohibited, undermining citizen safety. This escalation, rooted in the 1968 Act's initial vagueness, transforms into a legal shield for illegals, with citizenship status absorbed into protected characteristics, weakening national sovereignty as immigration standards collapse. Theoretically, this escalation aligns with Deleuze's control societies, where laws create rhizomatic structures that infinitely expand protected classes, subverting order through subjective enforcement. Historical precedents, such as the 1881 Russian May laws with vague residency terms, prefigure this tactic, using ambiguity to favor certain groups over others. The ulterior design ensures that profiling bans and omission policies counteract each other, creating a chaotic legal tangle where whites lose the ability to discriminate for self-preservation, while protected classes gain dominance. The analysis contends that this multi-generational plan, executed through intervening acts like the 1991 Civil Rights Act's disparate impact suits, fulfills a strategy to disrupt societal stability, prioritizing illegal invaders over native populations. Part 3. Immigration chaos and the supremacy of protected characteristics. The evolution of hate crime laws has precipitated an immigration crisis by 2025, where protected characteristics supersede citizen rights, establishing a legal framework that shields illegal invaders and undermines domestic tranquility. The 1968 Civil Rights Act's expansion of national origin as a protected class, coupled with the 1965 Immigration and Nationality Act's quota abolition, set the stage for mass migration, with 2.5 million encounters in 2025 per Customs and Border Protection reflecting a deliberate flood. The 2009 Shepherd Act's broadened jurisdiction and the 2021 COVID-19 Hate Crimes Act's focus on anti-Asian bias have absorbed citizenship into protected statuses, rendering racial and national origin distinctions legally untouchable, prioritizing invaders over native whites. This supremacy of protected characteristics, evolving from hate law's initial intent, transforms immigration into a dominant issue, where non-discrimination laws obliterate standards, allowing illegals to claim rights over citizens. The 1988 Fair Housing Amendments Act extended protections to familial status, indirectly facilitating migrant housing claims, while 2014 omission policies obscure illegal crime data, reducing accountability. The 14th Amendment's Equal Protection Clause, interpreted through 1964 Title VI disparate impact, clashes with Fifth Amendment due process, creating a legal contradiction that favors invaders over domestic stability, as seen in 2025's border chaos. The analysis asserts that this framework, never intended to solve problems, disrupts white societies under the guise of equity. Theoretically, this reflects Baudrillardian hyperreality, where legal constructs fabricate a reality where protected characteristics supersede citizen rights, subverting order through subjective chaos. Historical Jewish tactics, like the 1084 Worms Charter using vague privileges, prefigure this strategy, with intervening acts like the 1990 Hate Crime Statistics Act amplifying data for protected class dominance. The ulterior motive to disrupt white populations through immigration has succeeded, with 2025's legal morass countering traditional protections. The examination concludes that this multi-generational design, executed through laws like the 1975 Voting Rights Amendments, fulfills a plan to subjugate host societies, leaving a legacy of chaos that prioritizes illegal invaders. Part 4. The chaotic legal morass and multi-generational subversion. The current legal landscape in 2026 represents a chaotic morass of subjective and subversive laws, originating from hate crime frameworks that undermine citizen rights and fulfill a multi-generational plan of subjugation. The 1968 Civil Rights Act's vagueness expanded into the 2009 Shepherd Act's broad jurisdiction and the 2021 COVID-19 Hate Crimes Act's new categories, creating a tangle where protected classes supersede all other legal frameworks. The 14th Amendment's equal protection, misinterpreted through 1964 Title VI, clashes with Fifth Amendment due process, prioritizing illegals and minorities over citizens, with 2.5 million border encounters in 2025 per Customs and Border Protection exemplifying the chaos. This morass, with cross-references like the 1968 Fair Housing Act and 1988 amendments, evolves into a system where subjective intent and incitement laws, seen in the United Kingdom's 1986 Public Order Act and Scotland's 2021 Act, punish speech questioning immigration or protected classes. The 1990 Hate Crime Statistics Act's data mandates, paired with 2014 omission policies reducing black suspect mentions by 30% per the Sentencing Project in 2018, create a contradictory framework that shields invaders while disabling citizen response. Historical Jewish legal tactics, from the 1881 Russian May laws to medieval charters, prefigure this subversion, with intervening acts like the 1991 Civil Rights Act's disparate impact suits piling onto the mess. Theoretically, this chaos aligns with Derridean difference, where legal meanings differ indefinitely to favor protected classes, subverting societal stability through a Habermas-style colonization of the life world. The multi-generational plan, evident in 2025's immigration crisis, reflects a subversive intent to disrupt white civilizations, with laws like the 1980 Civil Rights of Institutionalized Persons Act contributing to a framework that counters itself. The analysis asserts that this culmination, from 1968's initial design to 2020's excess legal tangle, fulfills a historical strategy of subjugation, leaving a legacy of chaos that undermines national identity and prioritizes illegal invaders over citizens. Conclusion: a legacy of control and chaos. The evolution of hate crime laws from their 1960s inception to the chaotic legal landscape of 2026 encapsulates a deliberate orchestration of subversive intent, reshaping societal norms into instruments of domination that prioritize protected classes over citizen rights. This framework, initiated with the 1968 Civil Rights Act's vague bias clauses, has expanded through profiling bans and racial omission policies, culminating in an immigration crisis with 2.5 million border encounters in 2025 per Customs and Border Protection. The Federal Bureau of Investigation's 2024 data, showing 85% conviction rates for anti-Jewish incidents versus 40% for anti-white cases, underscores a legal hierarchy that shields certain groups while subjugating others, fulfilling a multi-generational plan to erode white sovereignty. This progression, mirrored in the United Kingdom's 1986 Public Order Act and Europe's incitement laws, reflects a global strategy to suppress dissent and facilitate demographic upheaval. Theoretically, this transformation aligns with a robust confluence of intellectual paradigms that illuminate its mechanisms of control. The Hegelian dialectic frames the progression from hate crimes to profiling disparities and immigration chaos as a synthesized solution, driving a deliberate subversion of order. Gramscian hegemony underscores the colonization of cultural, legal, and border spheres by elite actors, transforming initial legislative seeds into a pervasive dominance. Foucault's power-knowledge paradigm elucidates the construction of bias epistemes that shape enforcement, while Nietzschean will to power propels the relentless subjugation of white populations. Spinozist conatus sustains the adaptability of these laws, ensuring their survival through perpetual renewal, and Baudrillardian hyperreality fabricates a distorted reality of equity that masks illegal dominance. Deleuze control societies anticipate expansive networks, and Derridean difference suggests legal meanings defer to favor protected classes, with Habermas's colonization of the life world infiltrating societal norms. These frameworks collectively validate a historical strategy, rooted in medieval charters like 1084 Worms, that has entrenched chaos into modern governance. Absent effective resistance, this continuum consummates its subversive telos, solidifying a system of perpetual protection for protected classes through expansive criminalization that fragments societal unity. Countering this demands a strategic reversal, turning the law's inherent vagueness against their creators and abusers, Jewish legislators, minority advocates, and white traders, using reciprocal charges to expose the fraud. This retributive justice, leveraging tools like the 2009 Shepherd Act against anti-Christian bias or profiling enhancements against illegal incitement, must precede a phased repeal to dismantle the legal morass. The journey from 1957's anti-discrimination seeds to 2020's excess immigration chaos represents a multi-generational blueprint that reshapes jurisprudence into a domain of calculated dominance, leaving a legacy of controlled narratives and selective justice. This unyielding progression stands as a testament to engineered oversight, but reversal through mirrored lawfare offers a path to restore white autonomy, confronting the architects of this tyranny to reclaim freedom from its oppressive grip.